go again.
Here we are.
You ready?
I'm ready.
Let's go.
Okay. Hi, everybody. I'm Rick,
And I'm Robert.
and welcome to our show, Conflict, Mediation, and You.
And today we're going to talk about a couple of things. We're going to give you an overview of three stages, if you will, of things that we're going to be talking about. And those three things are the court-mandated mediation, if you will, and then the other one will be self-selected.
Yep,
Self-selection. And what's the third one?
Attorney recommended.
Oh, yeah, those guys.
Yes.
Those guys,
Yes.
okay.
Three
All right.
ways to get a mediator.
3 ways to get a mediator. So the first part that we're going to talk about is the mediator. And we've talked about mediation and the mediator before.
Yes.
So what you're going to hear might be a little bit of a repeat of what was said, but we think that's necessary. And in the case of small claims court,
Court-mandated. Yep.
Court-mandated mediation, then a mediator is part of, part of the court system, but not really part of the court system, but they are there. So you get the mediator who's assigned to your case.
Yes.
Okay? And you've done that 100 times. I've done it many times.
Yep.
And you really, you get what you get.
Yes.
So the mediator is assigned by the court.
Yeah.
And in order to be a mediator in the court system, you have to be on that court system's list of mediators, if you will. And if you're on that list and the judge selects you, well, maybe it's not so much selection as you're in the rotation.
Right.
So your number comes up and
Yes.
you get the court. So that's how someone filing in small claims court would get a mediator for their case.
So if I get served and I have to go to court and I get a court date to show up, and I walk into the court and sit there and the judge calls the calendar, I don't get to pick my mediator.
No.
They're going to give me a mediator.
Well, the way that it goes most of the time is that your case is called.
Right.
And the judge is going to say that he or she wants you to try mediation. So you're pretty much told that you're going to go to mediation, and then the judge or the clerk would look over to the bullpen to see who's next in line, what mediator is next in line, and they would say, that's your case, and then I, as the mediator, would be your mediator.
The person who filed against me and me, we go back there with this person we don't know.
Right.
And sit down, and we have to mediate that.
And you're going through a process that you might not be familiar with a mediator who, in all probabilities, you don't know either.
Right.
So there are a lot of unknowns in that system, and it's a good system. It does work.
Yeah.
But it might not be the best for you and what it is that you want to determine for yourself.
Sometimes these mediators in these programs on these lists have a great deal of experience. I mean, they're there a lot, and they do it over and over again.
Yeah.
So you could get a really good mediator. Plus, the training, you have to be by GODR,
Right.
which is
Georgia Office of Dispute Resolution.
And there's regulatory outcomes that the state expects. So you're trained in a particular way. And all those mediators in the court have been trained by those standards.
They have to be trained, yes.
Okay, all right.
And they have to be on the state mediators registration list.
So this isn't just somebody that walked in off the street and said, hey, I'd like to sit in the bullpen today.
No.
Okay,
No. No, these are trained mediators, and as you said, they have many hours of training and many hours of providing mediation.
Okay.
Because they're doing it in the court, they're also probably doing it on their own in their private practice. So they have experience.
Okay.
Okay, and the experience might be way more than what's needed for your particular case, but that's okay.
Right,
That's what you
right,
want,
right.
so, okay.
So I could get a really good mediator, maybe, that's just here in the courts helping out?
Yeah,
Okay. All
yeah,
right.
99% of the time, you are gonna get a good
A
mediator.
really good mediator?
Yeah.
All right. So I don't need to worry as a client going in and the judge making me do this?
No, because again, before a mediator sits in the bullpen to hear a mediation, a court mandated mediation case, they have gone through all of the steps necessary to get there. That's the 40 hours of training,
Yeah.
all the practicums, and then all of the cases that they have done over several years probably. So,
Okay.
yeah.
So that can be good.
It is good. It can be good.
Okay.
So that's one way. Then there's the mediator is part of that process. Now, the next part of that is the context of what takes place.
Yes, the context. I want to talk a little bit about that. In the court mandated programs, there's usually a time limitation where the judge is listening to all these cases, and all these cases have to be finished by the end of the day. And so some go to mediation, some the judge will continue to hear, but it has to be resolved that day, either in mediation or by the judge. So you don't get unlimited time. You don't get to think about it. You don't get to go home and mull it over. You don't get to run it by an attorney or a friend. You have to make a decision there, or the judge will settle the case for you. That time limitation in the mediation can be disconcerting. It's got some pluses, it's got some minuses. One of the minuses is it may feel like you're being pressured to get this done.
Who's setting this time?
Well, it's usually the court calendar. Depends on, if you're early on, you may get maybe an hour to work it through. If you're later in the day, you may get 30 minutes, 20 minutes. What will sometimes happen, and this has been my experience, is I'll get a knock on the door, and the court coordinator will open the door and say, the judge is ready. Are you close? If you're close to an agreement, they'll let you stay there. But if you're not close, then they expect you to finish this up and get back for the judge to make a ruling.
Well, you're in the middle of a mediation, and someone comes and knocks on the door to let you know that your time is up.
Close to up, yes.
That doesn't seem fair.
Yeah, it is a downside of the court mandated. If you're going to get a mediator and it's going to be assigned to you by the court, there's going to be some time limitation. You don't get the kind of freedom with your time and decision making that you do in the other processes of getting a mediator. The other thing that's problematic and can be a negative is the mediator is there, and one of the questions you want to ask as a consumer of mediation, who does the mediator serve? So you're not paying the mediator. This is a free service to you through the courts. So who does the mediator serve? In this magistrate court programs, it's the judge. They're there to help remove the cases off the judge's docket. And so what the judge sees as important, one is time consideration. All the service, all the extra work, all the direction that this is all going is framed around what the judge is expecting.
So having my case be heard, if you will, by a mediator probably isn't to my benefit.
It can be of greater benefit than going straight to the judge.
Well, from what you just said around the time and the constraints, it would be faster.
It would be faster. However, the judge has their hands tied. Whether he or she is making a ruling, they have to make a ruling around the law. When you're in that room with a mediator, there's much more freedom and flexibility to work out a plan where both people could be happy. When you stand in front of a judge, there's one winner, there's one loser, or in some cases, two losers.
Yeah.
And so it is worth the time to give it a try. And if you know what you're doing and you understand what's happening in the setting, that's partly why we're doing this, is so you as a consumer of mediation going to court will have a better understanding of what to expect and how to best use that process. The last thing about the context. And this probably has, I don't know, it could be equal pros and cons. So tell me what you think. With sitting in that room and you know that the judge is just around the corner and the case is going to be heard today, it's going to be settled. At the end of this day, you're going to have a judgment or a resolution, one of the two. The tendency in the mediation is to only think in terms of, well, what will the judge do? What will the judge do? What will the judge do? Do you think the judge will like your story? Do you think the judge will like your evidence? Do you think the judge will side with you? Instead of the possibility of thinking, well, what's most important to me? Instead of what am I risking going in front of a judge? Does that make sense?
Yeah, it makes sense, but I'm thinking that if I'm sitting there knowing that I only have 15 or 30 minutes to make a decision or for a decision to be made,
Mm-hmm.
and it might not be my decision, then I might not have a very high comfort level going through this process.
Yeah, indeed. And I've seen people who've never been in mediation before just really at a loss of what this is about, what's going on, what can I do, what can I not do. Is this... Most people are afraid to go in front of the judge, so they feel a little more comfortable doing this, but they don't know what this is, and consequently they can't maximize this opportunity.
So, and I know the answer to this, but given that you're working under the time constraint, then the mediator really doesn't have any time or very little time to explain the process to the parties.
There's a number of things that sometimes get shortened. A mediator's opening statement, they don't have the time to go through the whole thing necessarily, and some of the techniques that are available to a good mediator to help negotiate, to set the framework, to set the stage for a good negotiation, to explore options. Some of those aren't readily available as they would be in, say, a private mediation.
So if the parties have a choice of rather to go to small claims court and mediation or private mediation, then the choice might be, or a better choice might be, private mediation, which we'll talk about later.
We will, and where we get the self-selected, where you get to pick the mediator. And it may even be possible, if you get served with someone suing you to go to small claims court, to call us and to work through it, because it may be possible to file a motion that asks the judge to send your case to mediation prior to the court
Before
date.
going to court.
And then
Yeah.
you're going to have, you can show up in court with an agreement, and you can have all of the benefits of a private mediation.
Yeah, okay.
It's time for a break. Let's take a moment and hear from our sponsors.
Okay.
10 years to learn the business. 10 years to make a name. 1 year on your own. It takes time to build a small business, but only 60 days to transform it with email marketing from Constant Contact. Sign up with Constant Contact and get 60 days of free email marketing to generate referrals, connect with clients, and build the business you've always wanted. Constant Contact. Start your 60-day free trial today.
What happens when soldiers come home? Brene Foundation offers hero support to ensure that our heroes abroad can continue to be heroes at home. We link veterans with organizations who are dedicated to guiding the transition from military hero to civilian hero. If you want to find out how you can support our troops at home, please contact the Brene Foundation or visit brene.com.
Okay, we're back and we'll continue with our discussion around the small claims court and mediation and how all of that works. And we've talked about the mediator and also the context of the process.
Yes.
So the next piece of that would be the what we're going to call evidence. Now, I don't particularly care for calling it evidence, but that's what it is. So
Yeah. Yes. Evidence. See, one of the problems with people coming to mediation or even coming to small claims court at all is they don't understand the rules of evidence. And the judge is forced to make decisions around what's acceptable to be heard and what's not acceptable to be heard based upon Georgia rules of evidence. So one of the things that they'll come for the example that all the judges use is in their opening statement. It's a car case. A mechanic has fixed your car. You've paid them, thousands of dollars. You drive off the lot 2
And the
blocks,
wheels fall off
and
the
it falls
car.
off. You want your money back, and you sue to get your money back. And so there you are in court, and you've got estimates. You've got written testimonies. You've spoken to different people about what's wrong with your car and the fact that, yes, this guy really screwed it up. And they'll come with all of this stuff, and they'll stand in front of the judge, and they'll want to bring it for the judge to accept.
we'll see, yeah.
And the judge will reject it every single time. It's called hearsay evidence. If the person you talk to is not in fact in the room, so that they can say, yes, that's what I said, or say it themselves in front of the judge. If you have an estimate from another mechanic and that mechanic is not in the room, it's considered hearsay evidence and thrown out. So you have people, I've seen this over and over and over again, they come thinking that they've really worked hard on their case, that they've really collected strong evidence, and the judge throws all of it out. None of it counts for anything, which pretty much ends up meaning the other person wins. So evidence, talking in front of a judge, requires some knowledge of rules of evidence. The evidence is designed to influence the judge's decision, and it's a legal decision, so it has to follow legal procedures.
Okay.
The other thing I see people come, this all the time, there's a big difference between the law and morality. So the fact that the mechanic did a bad job is unethical and won't give your money back is immoral, right?
Okay.
I've had people come in and they felt wronged, they've mistreated, they've been hurt or something, and this is morally reprehensible. But there's no legal basis. And so they want to come in and tell the judge, like they would their friend, oh, you would not believe what happened to me. You would not believe what they did. The other person's going, oh, that's horrible. That's terrible. And they do the same thing to the judge, and the judge goes,
So?
I mean, it's just so discouraging. So they ramp it up and try to get more patent. So the story isn't enough to influence a judge. And so their case unravels right before them. In mediation, across the board, evidence works completely differently. When you walk in that room with that court-mandated mediator, even with the time constraints, the rules of evidence don't apply. You can tell your story to the mediator and to the other person. You can show those estimates. You can show those comments from the other mechanics. It's all admissible in mediation.
Now, what's the benefit of showing all of that to the mediator?
Where rules of evidence in the courtroom is designed to influence the judge's decision, evidence in mediation is designed to persuade the other party. So anything that will convince the other party to do what you're asking them to do is acceptable.
So you're not really so much, you're showing the evidence, as you call it, to the mediator.
Yeah.
But your purpose is really for the other party to see it,
Right.
to convince them that you are right.
Because the mediator doesn't make any decisions, so what, you hand it to me on the mediator, I look it over, and then I turn to the other party. Have you seen this? Yes, no, they look at it, and they get to tell their story. And in the mediation room, the story can be powerful. You wronged me, you hurt me, this was inappropriate, this is unacceptable. And it could have an influence on the other party, and you may convince them to do what you're asking them to do. Repair the car, give me back my money, something like that. So it's very different inside that mediation, what is acceptable. In some ways, the mediator has far more leeway than a judge does. That's partly why judges like mediation, because they're often bound by these rules, procedural rules, and bound by precedent of law.
And the mediator isn't.
Is not.
So, okay. So, the rules of evidence, storytelling. So I get to tell my story, and in the process of telling my story to you, the mediator, then the party also hears it and could hear something different from what they heard before, and it could convince them to agree with me, to settle in my favor, or not necessarily in my favor, but for an agreement to be reached that both of us can live with.
Yes,
Okay.
it could change the other person or soften them up. Whereas in the courtroom, you may never get a chance to tell your story.
Well, if I've hauled all this stuff in and a judge says it's no good, what do there's nothing I can do then.
You're stuck.
So, okay, all right.
Now, one of the other benefits of mediation is that the decision that's made is yours to make as opposed to the judge.
Yeah.
Say more about the decision.
Well, in the mediation, the part of the purpose of the mediation is for the parties to come to an agreement, and hopefully the parties will come to an agreement that is satisfactory to both of them. So no one will walk out at the end feeling like a loser, which is what mediation is about. So if we can get to that point where the parties come to an agreement, then as they're working towards that, they're going to feel empowered because they're part of the process. And the more they feel part of the process, the harder they'll work. Both parties will work to come to an agreement. Now that sounds like it's an easy process, but there's some things to consider in that. Is that everything that happens in that mediation, in that room, has to come from you, the party.
Okay.
Yeah, I mean, you can't call a stop and get advice.
Okay.
Okay, you can't do that. I mean, you can't say, wait, hold on a second. I want to call my Uncle George and find out what he did when he went through this. You can't do that. I say you can't do it. You can't do it in the moment. You do have opportunities to get advice.
Yes.
But if you're working under time constraint, then you really, to say, I want time out so I can seek legal counseling, most of the time you're not going to get that. So everything is going to be up to you,
Okay.
the party, to do that. And in that process, and again, with the time constraints, the mediator can't say, hurry up and make a decision. In other words, the mediator can't coerce you into making a decision. So you're left to make that decision on your own, which again can be, and in most cases is, empowering to the parties, knowing that they're going to make the agreement and that it'll be theirs. And they can walk away with something they can live with.
What if that could be pretty scary? I mean, I don't know anything about the law. I'm supposed to make a decision?
Yeah, well, you might not know anything about the law, but you know what you want. You know what you need.
That's true.
So in many cases, the law has nothing to do with it. I mean, if my car, in the example that you gave, if my car isn't running,
Mm-hmm.
then one thing I want is my car to run. I
Uh-huh.
want to be able to use that car. So if I can, in the process of storytelling back and forth between the parties, the repair person says, okay, I understand, and I'll redo the car. We'll fix it. We'll make you whole. Now, one of the things that you become, you're happy because you're going to get your car fixed.
Yes.
The other party might, maybe for them, they're happy because now you're not going to take out a full-page ad in the paper saying what a lousy job they did. So you're both, in a sense, I make light of that, but in that case, both parties will win.
Can walk away
Yeah.
with
Yeah.
feeling better about it. What if I want the judge? What if I don't want to make a decision?
Well, I've had a couple of cases where parties have said, you know, I don't like this process. I want to go before the judge. And they have the right. I mean, this
Okay.
is a voluntary process, so if at any time you feel that it's not going the way that you want it to go, then you can stop it.
Really?
You can stop it, the mediator can stop it, and the other party can stop it.
Huh.
And you already have, you're already on the court docket, so you just go back in front of the judge. The thing about that is that what I try to get the parties to realize is that if you go back in front of the judge is going to make the decision.
Right.
Not you, not the other party. The judge is going to make the decision. And somebody, as you stated earlier, somebody's going to walk away a loser,
Mm-hmm.
and someone might walk away a winner.
Yeah.
And you might walk away, you know, literally walk away because your car might not get fixed.
With nothing.
You know, you're left empty-handed.
There is another drawback of having the judge make the decision. There's a judgment. The judge can make a judgment against, say, the mechanic that messed up my
Right.
car. And what a judgment means is that the judge has decided that you were right and the mechanic was wrong, and the mechanic owes you money, right?
Right.
However, the judge can't make the mechanic give you money. That's part of the problem. You can win,
But you still
don't get your...
don't get what it is that you're after.
And there's a bunch of things that you can follow up on, and it's your responsibility to have to do that. It's your responsibility to get the money from the mechanic, and you can do garnishments and stuff like that. I mean, you can seek legal advice for how to do that. In the mediation room, we actually have ways, the mediator, to create payment plans. Judges can't create payment plans. Mediators can in that room. So not only could you get your car fixed or get your money back, you can outline a plan together that both of you find workable.
Now, when you say work out a plan, you, the mediator, isn't the one working that plan out. The parties are working that plan out between the two of them.
Right.
And you're just facilitating that process.
Yes.
Okay.
One thing we want to make, go ahead.
No, that's okay.
One thing we want to make very clear, mediators do not make decisions. They are not arbitrators. Arbitrators make decisions. Mediators never do.
Arbitrators and judges make decisions.
Make decisions.
Mediators facilitate the process of getting to
Yep.
an agreement. Okay, and we are pretty much, we're at our destination now, so we need to find a parking space.
All right, let's park the car and get out.
And we'll move on from there.
See you next time.